Welcome, ladies and gentlemen. This is the Cuyahoga County Public Safety and Justice Affairs Committee meeting this Tuesday, December 12th. Roll call, please.
And just as a reminder to all who are in attendance, this meeting is being recorded and live streamed on the county's YouTube page. Calling the roll, Mr. Gallagher.
Here.
Ms. Conwell. Ms. Conwell is absent. Mr. Tuma.
Here.
Mr. Kelly.
Here.
Ms. Simon.
Here.
There's a quorum. Also like the record to reflect that Council President Jones and Councilman Miller are in attendance.
Welcome, gentlemen. Public comment?
Yes, Mr. Chair. Ms. Leah, is it Winsberg?
All right, let's try that. Okay. Good afternoon. Thank you, Chair Gallagher, Vice Chair Conwell, and members of the Public Safety and Justice Affairs Committee. My name is Leah Winsberg. I'm the Senior Policy Attorney with the Children's Law Center, and we are a nonprofit legal services center that provides services to protect the rights of children and youth in the child welfare, juvenile justice, and education systems. We do this so that they can grow up in safe and healthy ways, and we achieve our mission through direct legal services, policy reform, and community education. I'm based here in Cleveland, and I work statewide to improve how young people are served by both the juvenile and the adult justice systems. Today, I'd like to highlight a few priority opportunities that I believe will help us better serve our county's justice-involved youth. I'm confident that members of this committee share the belief that youth safety and well-being is vital to our county's overall health and wellness. Supporting children's healthy development must also include a commitment to preventing youth from entering the justice system and from going into the deepest ends of that system. Despite what we've been hearing recently in media coverage, our county, like the rest of the country, has had an overall steady decline in youth crime since the 1990s. Our juvenile court has been processing less official delinquency cases since 2018 than in the previous 20 years. Nevertheless, we're seeing an increase in the number of children winding up in our local detention center and those committed to Department of Youth Services, which is our state youth prison system, as well as an over-reliance on transferring youth to adult court. We know that incarceration fails to address the root causes of delinquency, and it fails to effectively prevent future reoffending, but it also has devastating consequences on youth. A recent study from Nationwide Children's Hospital found that formerly incarcerated youth in Ohio's DYS facilities are significantly more likely to die than their peers, 6 times more likely for boys and 9 times more likely for girls. Similarly, another recent study found that youth incarcerated in adult facilities also have a greater risk of death by 33%. Youth in adult facilities are also 5 times more likely to be sexually assaulted, 8 times more likely to commit suicide, and twice as likely to be attacked physically. A recently published special investigative series highlighted some of these pervasive problems, including those plaguing Ohio's youth prisons and detention centers, prompting our governor to create a special work group to conduct a thorough, holistic review and issue recommendations for improvement. Our county should likewise commit to creating an ongoing system for monitoring our county juvenile detention center to ensure that our youth are safe and have access to appropriate education and trauma-informed behavioral health and other supports. Too many pathways lead children to justice system involvement, and unfortunately, Cuyahoga County's children are overrepresented in the state's legal systems. Cuyahoga County consistently leads in the number of youth statewide who are detained pending trial, the number of youth. Is that my timer? Okay. Thank you, Chairman. The number of youth committed to the state youth prison system and those transferred to the adult court system. Over 2/3 of youth in Cuyahoga County's juvenile justice system had prior child welfare involvement, meaning they already experienced abuse, neglect, or significant trauma. Contact with the justice system, especially being detained or incarcerated, is often uniquely traumatizing for young people, and youth in the Cuyahoga County Juvenile Detention Center are often isolated for extended periods of time, disconnected from families with scarce programming or therapeutic supports. The JDC is intended to be a short-term placement facility for stays of 90 days or less. However, youth facing bindover are detained on average for 225 days. Given all of this, our county must also be committed to ensuring that no child faces this legal system and these potential consequences without competent, qualified, and robust defense counsel. A report released last week raises serious concerns about our juvenile court's indigent defense system and the quality of representation provided to this vulnerable population. We also need to do more to keep our young people from entering the juvenile justice system by investing in more prevention efforts like JDAI, which is the Juvenile Detention Alternatives Initiative, and the EIDC, the Early Intervention and Diversion Center run through the court. These system efforts strive to prevent youth from going deeper into the system. We have a unique opportunity to assess and improve in these areas. I urge the County Council to create a youth justice working group with diverse stakeholders to encourage system collaboration, identify priorities for urgent improvement, and to invest in relational supports that foster connection, healing, and restorative experiences for our young people. Investing in the success of our justice-involved youth not only helps their growth successfully into adulthood, but also bolsters our community at large. Thank you for your time and attention to these concerns.
There's no one else signed in.
Thank you. In your packet, you have the minutes of our November 21st meeting. If they're in order, I'll accept the motion in a second.
So moved. Second.
A motion, a second. Discussion? All in favor?
Aye.
Aye. Against? Thank you. Matters referred to committee are none. Discussion? We have a presentation from Juvenile Court. Administrative Judge O'Malley. Judge, thank you for being here. As you well know, we during our budget process, we went through some upheaval, and I thought the question needed to be answered publicly and directly from you as to what we were actually talking about. Some people up here, especially the attorneys, certainly know the process. Others, such as myself, as lay people, might have an idea what's going on, but in reality, we don't know what we don't know. So if you could take us through the juvenile court process, and the floor is yours.
And, oh, there we go. And I brought, accompanying to me today is the Honorable Judge Jennifer O'Malley, who is going to speak to you about the bind-over process. She just recently presented it as a CLE, continuing legal education, so I figured she was the best one to discuss that with you. We also have our court administrator, Tim McDevitt. We have magistrate and former county public defender, Mark Stanton, Bridget Gibbons, who's our deputy court administrator, and then Sarah Sidgick, who's a deputy court administrator and our chief legal counsel. We did a deep dive after, actually before that RUN article came out, RUN Collaborative came out, and our statistics, surprisingly, are a little different than what has been laid out in that article. And Sarah herself did the deep dive. She conducted it, she analyzed it, and therefore I think she would be in the best position to present that to this body.
Judge, may I
sure.
interrupt? Regarding this REN group, I got a copy of it from you and actually from some person from the GCC. It was signed by no one. Did they talk to anybody in the court when they did this?
When we met with the GCC, I think it was October 3rd, October 2nd, we were informed that there was a report coming out from the RUN Collaborative or the RUN group. We asked for a copy of it. They indicated that they weren't willing to give us one at that time. We tried to get copies of it, and we received it. Actually, I didn't receive it. Someone else received it and sent it to me.
Are you aware if they've talked even to the prosecutor or the public defender?
I'm not aware.
Public defender, are you here? You want to come forward?
Good afternoon, Chairman. Cullen Sweeney, County Public Defender. The REN Collective, as I understand it, is a nonprofit group that is doing research nationwide about indigent defense systems. They picked 5 or 6 jurisdictions to look at, and one of them was Cuyahoga County. They did first contact our office sometime early in 2023, this year, to just talk about just to do some brainstorming about issues in Cuyahoga County. And then we've been in touch with them. They've asked us for some information. We've provided it over the course of the last 6 to 9 months.
Are you aware if they spoke with the prosecutor or the court?
I know that they did. Well, I did send an email to Judge O'Malley and CC'd Nikki Bazinski was the lead person on this report from the Wren Collective, and encouraged that they connect. But as far as that, whether anything came of that, I don't know. And I don't know if they reached out to the prosecutor.
But you participated.
Yes, I spoke with them, responded to their questions. They made some requests for information. I provided it. There was an ongoing dialogue, yes.
Okay. You don't find it odd that the court or the prosecutor didn't have that ongoing dialogue?
Well, I mean, I didn't publish the report, so I mean, I can't speak to that. I don't know if the prosecutor was approached or not. I know, my understanding is the court was, and apparently, I don't know what happened there, but.
Yeah, I just got a copy of it, cold. I didn't have a signature on it. I didn't know who they were, what they were, where they're from. I had to do some research on that. There didn't seem to be any mention of coordination within the county, which I found strange.
Yeah, I mean, sorry to interrupt, but
Go ahead.
I was just going to say, I mean, again, like I said, as the public defender, when organizations reach out to us for information, we engage them. We give answers. Much of this is public information, things of that nature. I know they reached out to other stakeholders, or at least that's what's indicated in the report. And I know that they're doing other reports. It's not like they were just focused on the juvenile justice system in Cuyahoga County. They were doing other reports, both in Cuyahoga County that are forthcoming, I believe, and then in other jurisdictions. But as far as the methodology of the report and that whole process, the person to talk to would be someone from the Wren Collective.
And it would have been, and I would have done that had they put their name on it.
Well, I mean, your Chairman, I can provide you the lead author's name, and I'm sure she'd be happy to speak with you.
Well, I would assume not, because I had to get it second party to get it to me. And quite honestly, I have nothing to do with it. But
Yeah.
it was forwarded to me, and I read it, and I just found it quite odd. And I got a little bit of a background with the courts, that you work hand in hand with your partners in justice, and that's the judges, prosecutor, and the public defender. And it seems that one of the three was participating with this group who I don't even know who they are, what they do, or where they're from until I researched it. And clearly they don't care about my input, or they would have sent me a copy, or someone a copy here through the administration. I'm not even certain the administration got anything. But we will go forward. I thought it odd that such a report with information, I hope all the information's correct, because now I know if it isn't correct, they got it from somewhere, and that somewhere is you.
Well, I know that they made data requests from the court, and they received some. So the data that I've read the report, the data upon which they relied came from the court. So for that, as far as bind over cases, case assignments, all those things came from the court. So we did engage with them and talked about our own experience in terms of vertical defense, and we provided them that information. But as far as court-wide data, that came from the court.
Well, it's public knowledge.
Right, but I was just explaining. You were suggesting it was all coming from us, but it was not.
Well, let's see where this goes. Thank you.
Mr. Chair, I do have a question of the public defender,
Yes,
if I
ma'am.
can.
Yes, ma'am.
What exactly did you give to them, this group, this organization? What exactly did you give to them
Well, they
specifically?
I mean, I can give you a list of everything. The only data related stuff was number of attorneys, number of bind over cases that we'd handled since we started our vertical defender system, outcome data related to that. They asked, we had meetings with them, and they asked us questions.
How many
and we
meetings
answered.
did you have?
I would say multiple conversations, more than 10.
And as far as you know, did they have any conversations with the public defender or the courts in commensurate to which they spent with you?
Do you mean the prosecutor?
Anybody
Well,
other
you
than
said
you?
the public defender. I'm sorry.
Yeah, I'm sorry. I stand corrected.
Yeah,
Prosecutor.
as far as I know, I don't have firsthand information. I
Okay.
know they reached out to the court. I don't know if they reached out to the prosecutor.
And you will provide our chair with a complete compilation of that which you gave to this organization?
Yes.
Everything? It's data that's in writing?
Yeah, anything that I provided them in writing, I will give to this committee.
Okay, and is this information different from that which you provided to the GCC? Because I know that you provided the information to GCC that they used when they testified in front of this body.
Yeah, the information, it was the same information that I presented to this body. So they used that information
So the
about our.
GCC has the same information, the organization has this information, but I heard that the organization wouldn't provide that to their findings. Did I just hear that in this committee?
It's
From that
What I heard-
somehow this wasn't disseminated?
This, what I heard the judge say was they did not give them a copy of the report before it was released. Yes. But
And why would that be?
I didn't write the report, so.
What do you think?
I guess again, I wasn't involved in those conversations. My understanding was they did want to meet with the court. The court didn't want to meet with them. I really don't want to speak for Judge O'Malley because he's standing right here. But my understanding is they wanted to meet with the court. I don't know why they didn't give them a draft of the report in advance. I'm not in a position to answer that.
Okay, when can you provide this, the information, the documentation to the chair?
I mean, I can go back to my office and get it together and
That
send
would be
it to you.
great, because it seems like everybody has that, but the people who have to make these decisions.
Honestly,
Saying-
I'm not sure I understand your inference there, but we presented bind-over data to this body at our budget hearing in where we were asking for another vertical defender. It's the very same information we provided to the GCC and to the Wren Collective. It's not something that we're hiding or only presenting to certain people. It's publicly available information from the budget hearing.
Well, we know that you had conversations with GCC and somehow had discussions about getting funding, the assigned council fees, and there's a bit of a muddy area about your involvement in their ask to have the assigned council fees be moved out of the juvenile court into your office. So the inference is based upon that which we heard during all these hearings about your involvement and how things came to pass. And now I'm hearing your relationship with this organization and providing them with information in the meetings and then that not being provided to the court. So there's a disconnect in how we should be proceeding. So I appreciate the chair's opportunity to bring the collective body together and try to resolve, what's best for the juveniles who are subject to this. So I appreciate your time, but please provide that to the chair.
And I just would like to address that Councilwoman suggested there's some sort of muddiness. I would like to know if you're suggesting there was something improper. I meet with community organizations that request information and provide it to them. I don't understand what you're suggesting was muddy or.
Well, there was money that was being transferred to your office, and then you said you didn't want the money and you didn't ask for the money, but somehow the money was directed to your office, and that's a little bit muddy how that would happen, that third parties just give your office money without your acquiescence. That's all.
Okay. Well, I'm telling you, we didn't ask for it. We presented our budget to the Public Defender Commission. We submitted it. I have email correspondence with the county executives that demonstrates that we did not know we were getting the $650,000. So, that's all I can say. And I'm sorry.
Can we have a copy of that email?
Absolutely.
I'd like to see that.
Anything else?
Okay, thank you.
Thank you.
Judge?
Before I sit, the first time I ever heard Wren Collective was in the meeting with the GCC in the juvenile court conference room around October 3rd, and that's when we were handed a piece of paper that said, will you agree to give 100% of all indigent youth to the public defender, meaning give all the cases, because under statute they're all indigent unless you got a retained attorney. And then this Ms. Bazinski, we heard there's a report. We asked for it. She wanted me to comment on it, and I said I can't comment on it until I see it. So it was a ping pong match. She would call, do you want to comment? I'd say I can't comment on it until I see it. And then like you, got it from a third party.
Okay.
And I think when, after Judge Jen O'Malley is finished, and then Sarah Sidgick on the public defender versus assigned counsel, I think the waters will be a little clearer.
Okay, good. Thank you.
Good afternoon.
Welcome.
All right, I'm Jennifer O'Malley. I'm one of the 6 judges at juvenile court, and I did provide a couple different handouts for you. I will say that these were not necessarily created by me. They were actually handouts that I received through my time as a former assistant prosecuting attorney. I believe a lot of the members of the bench also have these handouts, and they were very helpful to me when I was a prosecutor, as well as now a judge, in kind of having a cheat sheet or a flow chart on how to fully understand the bind-over process. So I'm going to try to do my best to explain the bind-over process to you. It can get very confusing. We have mandatory bind-overs, discretionary bind-overs, reverse bind-overs, as well as designations of serious youthful offenders. So the first thing I wanted to address is a lot of the bind-over process relies on age at the time of the alleged offense of the juvenile, as well as whether the offense was a Category 1 or Category 2 offenses. So when we're referring to Category 1 offenses, the statute's referring to aggravated murder, murder, attempted aggravated murder, or attempted murder. And then as it relates to Category 2 offenses, those types of offenses resolve around voluntary manslaughter, kidnapping, rape, aggravated arson, aggravated robbery, which tends to be our most common, aggravated burglary, and then involuntary manslaughter, that's a felony of the first degree. So there are 2 different types of bindovers. There are mandatory bindovers and discretionary bindovers. These motions or the request for transfer can be made, and I have always seen them made at the request of the prosecuting attorney. A child on his own or on behalf of his attorney can also ask for transfer to the general division, or the court on its own motion can do it as well. But I've always seen them done by request of the prosecuting attorney. So shortly after a case is filed, the prosecutor will review that and then will file either a motion as it relates to a discretionary transfer or a notice of mandatory bindover, notifying the court that it would be a mandatory bindover. So certain offenses, or when it could result in a mandatory bindover, is if the youth is 16 or 17 years of age at the time of the alleged offense, and they are charged with one of those Category 1 offenses, which would be aggravated murder, murder, or attempt to commit either of those. If the youth was 14 or 15 years of age at the time of the alleged offense, and they are charged with a Category 1 offense, so aggravated murder, murder, or attempt to commit those, and they previously have been adjudicated delinquent of a Category 1 offense or Category 2 offense for which they went to ODYS on that prior adjudication, that could become a mandatory bindover. If the youth is 16 or 17 years old at the time of the alleged offense and they're charged with a Category 2 offense other than kidnapping, mostly we see these on aggravated robberies. It would be mandatory if they have previously been adjudicated of a Category 1 or Category 2 offense and went to ODYS for that previous adjudication, or if they are the person that is alleged to have the firearm on or about their person during the commission of the offense, and that they either used that firearm, brandished it, indicated possession of it. So essentially, they're the one that had the firearm on their person. If they are complicit in that, so if they're 16 or 17 and it's an aggravated robbery and they're not the person that had the firearm, that would not be a mandatory bindover. Once a juvenile has a bindover case in juvenile court and they are bound over and transferred to the general division, if they are subsequently convicted in adult court
and then pick up a later juvenile case, under the law, they are no longer considered a juvenile. So their case has to initially be filed in juvenile court, and then it has to be transferred to the adult general division, regardless of what type of offense that is. And I think the youngest that can be done is if they're 14 years old. On discretionary bindovers, it can be as young as 14 years of age or older, and they were not subject to mandatory bindover, as I previously discussed, and they could be charged with any felony. So that's anything from, an aggravated robbery all the way up to a felony for RSP or theft offense. We don't see those, obviously, very often. When the state asks for a bindover, the first thing that the court can do is hold what's called a probable cause hearing. The court cannot send the kid for a competency evaluation. The court cannot hold a suppression hearing. The court can't even take a plea if the child even wants to enter an admission to the complaint as charged. So the only thing the court can do is proceed with that probable cause hearing unless the state were to withdraw that bindover request. At the probable cause hearing, the state has the burden to show that there's probable cause to believe that the juvenile committed the offense that they're charged with. They do not need to prove their guilt. And the standard of proof at that time is probable cause, which means that they need to show that there's sufficient credible evidence to believe that they committed the offense. The rules of evidence don't apply at a probable cause hearing, so hearsay is allowed. A lot of times detectives will come in and testify as to their investigation, but the rules of evidence do not apply. If it's a mandatory bindover and the court finds at the probable cause hearing that the state has met their burden, then the court is required under law to transfer that case. If it is a mandatory bindover and the state has met those factors and probable cause for each of the offenses. If it is a discretionary bindover and the court finds probable cause, the child is then referred to our diagnostic clinic where they undergo a psychological evaluation, which is in accordance with Juvenile Rule 30. That psychological evaluation is conducted in the clinic. There's an interview with the parent or guardian, the youth themselves, and then the clinician will gather any records that they can. They gather stuff from like the police reports. They don't talk to the youth about the actual offense, but they gather school records, any service that they have had through probation, through their family, through school, through children and family services, and then they provide a written report which is shared with the defense attorneys as well as the state, and that's a guide for the court at the time of the amenability hearing. It provides us with information regarding their school background, their social history, family background. It will have any mental health diagnoses in there. It sometimes has their IQ in there, and different services that may or may not have been put in place for them and whether those services were successful. So when we would come back for our second hearing, which is called an amenability hearing, that is, I provided a list of all the factors that the court must take into consideration under Revised Code 2152.12. There are factors that the court has to look at that are in favor of transferring a case to the general division, and then there are factors that the court must take into consideration that are against transferring a case. The court can also take into consideration any other relevant information. And then the court has to weigh those factors. And the case law shows that it's not a quantitative measure of the factors. You know, like there's so many in favor and so many against, therefore you have to bind them over. The court can choose to put the weight on it, whatever weight on those factors that we deem appropriate. At that hearing, the testimony can be provided, evidence can be provided. The rules of evidence don't really apply. I've had people, present exhibits, and then it's really just arguing the factors in the court, weighing those. And so we do take into consideration, some of those factors that are outlined on that sheet include, was there physical, psychological, or serious economic harm on behalf of the victim? Did the child have a firearm on or about his person? Did they have any prior adjudications? Were they awaiting adjudication? Were they under a community control sanction to the court? The court's required to look at the results of any previous juvenile sanctions and programs that indicate that rehabilitation will not occur in the juvenile system. So there's a lot that we need to take into consideration. And there's a lot that I take into consideration outside of what is just outlined in these factors. if at the conclusion of the amenability hearing, the court finds that the youth is amenable to rehabilitation within the juvenile court system, then the case would just stay in juvenile court and it would proceed, with a trial or pretrial on a separate day. If the court finds that the child is not amenable to rehabilitation within the juvenile court system and that the safety of the community requires subjecting them to adult sanctions, then that the state's motion would get granted and the child would be bound over to the general division. At that point in time, the court, in juvenile court, the jurist who's binding them over would set a bond, and that's not a right that they have up till that point. So we would set a bond, which they do obviously have the opportunity to post. The matter would then be transferred downtown where it would go in front of the grand jury for potential indictment. The juvenile would remain in the juvenile detention center pending any sort of conviction on that bind over. Once a juvenile, if they are convicted downtown by way of a plea or by a trial, that is when they get transferred from the detention center down to county jail. There is then what's called a reverse bind over. Before I get to that, does anyone have any questions regarding discretionary or mandatory bind overs? Yes.
Yes, ma'am.
I do. Judge, thank you so much for this overview. The question that I have is during that amenability hearing or the probable cause hearing, these factors that the court considered, do you see a difference in the presentation of the defense of that juvenile from either a public defender who has this vertical defense model versus an assigned counsel? Like how would a vertical defense come into play when the court's considering these factors that were already reviewed by your, I guess the equivalent to a PSI or?
Sure.
So tell me about that.
No, that is actually a great question. So historically, I have never had a difference between a public defender's presentation at amenability versus assigned counsel. I did have an amenability hearing last week. The case started out as a mandatory bind over. There was three kids actually charged. Two were mandatory, one was discretionary. On the two youth that were mandatory, the public defender represented one of them, and I found probable cause, but I didn't find that the state met their burden for it to be a mandatory bind over because I didn't think they had the firearms on them at the time. So it turned into a discretionary bind over. The public defender did they did present the prior probation officer to testify, which I've had prosecutors do that before too, and they also they stipulated to the doctor's report from the diagnostic clinic, but they still called the doctor to testify to ask just some follow-up questions, which sometimes the prosecutors will do or the defense attorneys will do. The only difference was at this hearing was that they did provide a report from a social worker in their office who was not present at the hearing, and that was the first time that I've ever seen that. It's never come to my knowledge that the public defender has used an investigator in any of their bind over hearings that have been before me. The state of Ohio did not stipulate to that report because they didn't know the authenticity of it or where that information was coming from. I did review that. I did accept it into evidence and I did review it. It did not provide me with anything that wasn't already in the diagnostic clinic report.
Isn't that a hearsay document, but the court can consider it,
Yes,
right?
yes,
Yeah.
because hearsay is allowed at probable cause hearings and amenability hearings.
So the only difference maybe that the vertical defense could provide, at least in your experience, would be this social work report
That works for their office, I believe, yeah.
That's probably going to be consistent with the very specific findings of the diagnostic clinic.
Correct.
Correct. Because they're pretty thorough, aren't they?
The amenability reports are usually around up to 20 pages, about 15 to 20 pages long of information. Yeah.
Thank you, Judge.
Any other questions before I move on to reverse bindovers?
So, Mr. Chairman, to the judge, thank you very much for this presentation. It's complicated enough that it can be beneficial to hear it twice, as I'm in the process of doing.
Yes.
And my question is regarding this material that you've presented. How How similar are state laws around the country on this kind of thing? Is it pretty consistent, or are there significant differences in state law regarding bindovers?
I honestly do not know the answer to that. I do know that our statute does recognize, which I've never seen a case come in front of me or when I was a prosecutor, but it does recognize the equivalent in other states would still, if they're charged with an offense here, it could still require a mandatory bindover based on equivalent laws in other states. But I don't know the answer to that question. I don't know if anyone else
Okay,
from the
thank
court
you,
does,
Mr.
but
Chair. Anything further?
I can look into that and let you know.
Yeah, that would be great.
Okay.
I would appreciate
Sure.
that. Thank you.
Okay, carry on.
Okay, so reverse bindovers. So this comes into play when a juvenile has been bound over on a mandatory bindover, when they were bound over when they were 16 or 17 years old at the time of the offense, and they were bound over on a Category 1 offense. So again, that's the aggravated murder, or attempt to commit either of those. Or they were 16 or 17 years of age at the time of the offense. It was a Category 2 offense, and they had a firearm on or about their person. Again, we usually see this in the aggravated robbery cases. So what happens is once they get bound over and they're convicted in the general division, whether that be by a plea or at trial, if the offense for which they end up getting convicted of in the general division ends up being a misdemeanor, the case is then transferred back to juvenile court, at which time the juvenile jurist will then impose a disposition under the juvenile code. If the offense that they are convicted of would have been a discretionary bindover, the case gets sentenced in adult court. They get an adult sentence. The matter is then transferred back to juvenile court. The state of Ohio has 14 days from the day that that journal entry is journalized downtown to object to what's called a serious youthful offender sentence, and I'll get into that in a minute. If the state objects within 14 days, it turns into a discretionary bindover in juvenile court. The juvenile is then referred to the diagnostic clinic. They undergo that psychological evaluation. We will have an amenability hearing, and then the court will make a decision as to whether or not to transfer the case. If the court transfers the case back after that, the adult sentence is immediately put into effect. If the court keeps the juvenile in juvenile court by way of the state not objecting to the SYO, or the court finds them amenable, the court is then required to impose a serious youthful offender sentence, which is a blended sentence. So they would get a juvenile disposition. They would also get an adult sentence under the adult code, and that adult prison sentence would be stayed pending successful completion of the juvenile disposition. As it relates to, did you have any questions about the reverse bindovers? So a lot of times we'll see that maybe if they were bound over on maybe an aggravated robbery would have been their Category 1 offense, mandatory bindover, and they had the gun on them, and then maybe they plea to a different, like a felony 2 robbery, the case would then come back. And so the judge downtown could give them anywhere from 2 to 8 years. They give them that adult sentence. It comes back. And then we have to either do the amenability hearing based on whether the state objects to that or not. And if we are giving, if the case does stay in juvenile court, we do have to, on the adult sentence, give deference to what the adult judge gave downtown. As it relates to serious youthful offenders, this is considered that blended sentence. So a lot of times when I've seen the serious youthful offender sentences, it's usually happens after the court finds a juvenile amenable and keeps them in juvenile court. The prosecutors then have 20 days from the court making that finding to file a notice of intent to seek a serious youthful offender sentence, which then means that they have the right to a bond at that point. They have the right to a jury trial, and that's the only time a juvenile has the right to a jury trial in juvenile court. So a lot of times the state will end up withdrawing these bindovers and work out a plea agreement with a serious youthful offender sentence attached to it. So we see that pretty often. The other times that an SYO can be initiated, it can be initiated by the prosecutor by getting a direct indictment at the start of the case, which I've honestly never seen happen. A bill of information, which is usually when they do that, when they're working out a plea agreement. If they charge it in their original complaint, until they then go to the grand jury and obtain an indictment, or which we see most often is the notice of intent to seek the serious youthful offender sentence, which I again said needs to be filed within 20 days, either after their first hearing on the complaint or after their motion is denied for transfer. There's also mandatory and discretionary youthful offender sentences. A mandatory one would require the court to impose that traditional juvenile disposition, and as well as impose an adult sentence. The court cannot impose a sentence of death or life without parole on those, and then you would stay that adult portion. As it relates to a discretionary youthful offender, so it has to do pretty much based on their age at the time of the offense and the offense that they're charged with. If it's a discretionary, the court must make a finding in order to declare them a serious youthful offender. The court must make a finding that given the nature and circumstances of the violation, the history of the child, the length of time, the level of security, and the types of programming and resources available in the juvenile system alone are not adequate enough to provide the juvenile court with a reasonable expectation that the overriding purposes of juvenile dispositions will be met. The court can then declare them to be a discretionary serious youthful offender. If someone is declared a serious youthful offender, there can be a motion to invoke that adult sentence at any point in time while they're serving their juvenile disposition. So that could be while they are at ODYS. It could be if they were placed on probation. It could be they've completed their ODYS sentence and now they're on parole. So at any point in time, this motion can be filed. And if they were serving their ODYS time at the time that the motion is filed, usually it's the Department of Youth Services will reach out to the prosecutor and ask them to file this motion. The child must be at least 14 years of age, and they had to have either committed an act that would violate the rules of the institution. That could be a felony or a misdemeanor offense of violence, or they engaged in conduct that creates a substantial risk to the safety and security of ODYS, the community, or the victim. If they're on community control at the time or parole, it's kind of similar. They would just need to have committed an act that is a violation of the conditions of their supervision. That could be a felony or a misdemeanor offense of violence, and they engaged in that conduct that creates a substantial risk to the safety or security of the community or the victim. If a motion to invoke the SYO is filed in court, the court's required to hold a hearing on it, and the burden at that stage is clear and convincing evidence that the juvenile was serving that juvenile portion. And if the court does choose to invoke that adult sentence, their juvenile sentence is immediately terminated and they begin serving their adult sentence. The court can impose that adult sentence that it previously gave them. You cannot give them more time, but you could also lessen that time and give them a little bit less. And that adult sentence can extend beyond their 21st birthday. And then they would get credit for any time that they served in ODYS. Any questions about any of that? No, that was a lot of information.
Well, probably one of the reasons I didn't go to law school. As a layperson, it comes down to mandatory discretionary, it seems to me.
Yes.
Which is the law.
Yes. So
basically, the court is hemmed in by the law, which is a good thing. So that would be 2152.10, 1202, and .121. To change anything, you would get in your car.
And drive down to Columbus.
Drive down to Columbus and start marketing your concerns to the elected officials in the state house.
Correct.
Not necessarily the Senate, but the House, which we are all represented by a state representative. And that would start the wheels moving as far as what you're bound by in the court.
Correct.
I don't think that that's usually, as a layperson, we think we can just change things. And that's really not a good thing. And so the recourse we have is to go to Columbus, preferably talk to your state legislator, to have them shepherd anything that you think needs to be done, as is done with every issue in the state of Ohio. And that's the process that has been in place since, as far as I could see, Ohio's been a state.
Yes, we take an oath as judges to follow the law. And
As we do.
yes, and that's what we do.
And that I think is, as Councilwoman Simon was saying, was muddying the waters substantially around here, is that people seem to think that we could just wave a magic wand and things would change. And if we could, believe me, we would do it, but we can't. But again, because we're bound by the same not the same oath, but oaths similar to what the judges and other elected officials in the county have to follow.
Yes.
Questions? Any further questions? Yes, sir. Mr. Tuma.
All right. Hey, thank you for being here today, Judge. Yeah, just hitchhiking off of what my colleague said. So there are obviously procedural and substantive due process safeguards in place here, and there is a process for appealing if there is an issue from a defendant, correct?
That is a great question. So I had a mandatory bind over recently, and I found that the state didn't meet their burden, and I found no probable cause, and I denied the motion. The state of Ohio appealed it. So it is now sitting in the 8th District, and we're waiting for the 8th District Court of Appeals to make a decision on that. If a juvenile is bound over, they can then appeal it after there's a conviction. So I know we've had cases that have subsequently resulted in a plea or subsequently resulted in trial, that it then goes up to the 8th District. And we've had cases even recently in the court get reversed after there was a plea in the general division and the person was already serving their prison time.
Right. So there's procedures in
Yes.
place, and that, as my colleague said, is kind of laid out by Ohio Revised Code and the court, the judicial process. So, you know, to me, this is kind of is what it is here, and you're following the law as is written, and I think providing information about this process is very beneficial, and we appreciate you taking the time to come out and explain this. I just want to know, can I get my CLE credits here today? I'm sitting through it. So.
Should, right?
No. All right. Thank you very much. Thank you.
Thank you. Any other questions?
Yes, please.
Thank you so much, Judge, for this. It's really interesting to me to get into the weeds on this. The two issues that were presented to us as a body, you weren't here, but the first issue was whether a transfer assigned counsel fees to the public defender's office would somehow change the dial on how many juveniles were bound over, I guess, in discretionary bindovers. And the sweet spot that I see here, the only place perhaps that the public defender versus assigned counsel come into play would be at the amenability hearing when the court considers the bindover. And you said that there's not much difference from your experience between the two, assigned counsel versus public defender, except perhaps that there's a social worker that will attach a report and they may or may not show up to present that, to allow it into evidence, and it's usually duplicative and certainly less than that which is done by your diagnostic clinic. Everything else you described here in terms of the reverse bindovers, and are there any other places where there could be a difference in an outcome between an assigned counsel and a public defender?
I've never seen it happen in the 5 years that I've been on the bench.
Okay, so that was the first issue presenting to this body, that somehow transferring assigned counsel fees to the public defender that they couldn't use. And secondly, that this vertical defense somehow would change an outcome or move the dial. What I'm hearing today is no, that's probably not the case, because we already have the diagnostic clinic that does a very deep dive into the juvenile's background and all these factors the court must consider. The second issue before us is whether there's too many bindovers. We heard that. But I think you just described the process, and Chair Gallagher rightly suggested and stated that you are bound by the law that's set forth by the Ohio legislative body. And do you have, I guess as a judge, you can't comment whether there's too many, but is there anything else that this body could do to change what the law already sets forth? I guess that's the question, if you can even answer that.
You know, I guess the answer would be twofold. I looked at since all this started happening, I started keeping track of my bindovers for this year. I have my own file where I keep track of every bindover motion that's filed, and then I write down the results of that. So it's easy for me to access. And I kind of briefly looked at it before I came here. And I will say that I did hold an amenability hearing the other day, which was the one that I was telling you about, which was the first amenability hearing that I've had in the past year. So it had been 12 months, a little over 12 months. I will say that in 2023, based on the youth that were in front of me, I had 18 kids that were charged with bindovers, 14 of them being mandatory. And they were all either aggravated murder or aggravated robbery where they were the person with the firearm. One of the juveniles has 4 pending mandatory bindovers right now. And I will say that of those bindovers, 6 of them were bound over. One of them chose to waive their probable cause hearing because they were on home detention at the time, and it was I think it was a homicide case or a manslaughter case, and the kid was on home detention, so the GPS monitor put him right there. One I found no probable cause on. One the state of Ohio dismissed because the kid was on home detention, and they were able to match up, that he wasn't at the scene. 2 of them turned in from a mandatory bindover into a discretionary bindover. One of those resulted in me finding the youth amenable. The other one resulted in the state of Ohio not proceeding with the amenability hearing and offering them a plea. 2 of them were withdrawn by the state of Ohio, the mandatory bindover request, and allowed the youth to plea. And 2 of them are pending. Of the 5 discretionary bindovers that were initially filed in front of me, the state of Ohio withdrew 4 of them and allowed for a plea. And I will say that the public defender was on 3 of these 18 cases. I will say that I follow the agreement that we have put in place with the public defender in terms of giving them cases that end in 1, 3, 5, or 7 unless they are conflicted out. And 2 of the cases that the public defender did receive, the child and his family then went and retained their own attorneys. And one of them went all the way through the process, and then I found that youth amenable.
Thank you.
Anything else?
Thank you, Judge. Oh, one more. Go ahead.
Thank you, Mr. Chairman. And
Thank you.
Thank you, Judge,
Sure.
for that presentation. I actually followed 85% of it. And, and it's because of loss or death in his family. So first you have my condolences. And, but I had an opportunity to meet with Administrator Tim McDivitt, who's here, and Judge Nicholas Celebrezzi.
Oh, yeah.
Who was present. And they were very insightful, very helpful to myself and my staff. We discussed bindovers, so I got that 101 that you, as Councilman Miller said, as you just repeated for us. It was very helpful to hear it again. But after that conversation, I had an opportunity to watch a bindover.
Oh, good.
With Judge, again, Nicholas Celebrezzi. He said, I'm about to do one now. Why don't you come in and sit and watch? So I got to experience and see just what it is, and so understand the amenability that would follow to determine whether he should be tried as an adult or not. So it was a good tutorial and a good baseline to help with our understanding here and how we move forward. So I receive what I'm hearing when it comes to the responsibility of the state for some of the things that are being asked. I've had many constituents come into this very room because there is no room other than this one for concerns around elected officials and the work that we do. And this is the room of accountability at times, or at least for access for the community. And so they throw everything at this 11 body as if we are to save all, fix all of everyone. And but what we learned over time is to just share what we do and what we don't and help redirect them. So what I took from everything yesterday was that I think there's an opportunity here to be more global than just $650,000 to a public defender or all those things. Almost put that to the side. Deal with it as necessary as this body, the bodies that are coming forward ultimately decides. But I just listened to Mr. McDivitt and Judge Celebrezzi and Judge Tom O'Malley, and just what are the needs? What are the needs of the courts? How do we as a body be a resource to support and be a part of the overall solution? No system is perfect. Not this 11 body, not the courts, and we all, sometimes we just operate in our silos, but there are opportunities when we can be supportive of one another and help, not in any way in terms of condemnation, but certainly in just support. Because none of our systems are perfect, but we are to work together. And that's what I expect when the time, over time, that we work collaboratively. We look at our strengths, our weaknesses, without condemnation, and say, what can we do to improve for the sake of the children?
I share the same goal.
Yeah, I say this, the majority of those individuals, I think someone gave me the stat, 97% of them are African-American. And I imagine the victims are similar, a similar percentage. I'd like to hear that in time. So what that means to me is, I'm going to say as an elected official, children don't vote, but their parents vote. And those are the ones who have elected me to serve them as best I can, which means their children as well. And so what do we do? How do we make sure that, work to make sure that our systems are being as effective as they can to serve the residents of this community? So with that, I always say, what can we have our hands on and that we, as a council, can do to be a part of the solution when we have no direct red lighting or green lighting of a juvenile justice center and that element of the criminal justice system. And in the conversation that I've had, it seemed around the resources that you mentioned earlier in your presentation. How do we pour, you didn't use the word pour into the lives, but this is what I inferred from what you said. How do you pour into the lives of these children preventatively? That seemed like a world where this body could probably play some level of support. So that's what I would like to maybe have you speak to a little more. Well, what type of things are needed for the children that are being held in this facility in that area or in the community, however you see it best? If you could speak to that briefly.
I think that's a great question, and it's something that I think we're always trying to find the answer to. I personally think that mentorship is a huge necessity. And I know that there's data that proves that obviously is very successful. I have met with Mayor Bibb and tried to figure out how we can collaborate with the city in different programs. I think that trying to have more supportive services, more services within the communities that these individuals are coming from, and trying to get these services early on, right? We also need buy-in from the parents sometimes, which can be a barrier. I think it's important for youth to sometimes talk to or be connected with individuals that have lived experience, because I think that it's important for them to see there's a lot of great people that we do have in the community that do have this lived experience, and they're trying to, work with the city and trying to work with our juveniles. And I think it's important for these juveniles to learn from them and see what they went through, and now the things that they're trying to help them do. I think it's important. A lot of these kids that we see in these immutability reports have lack of educational services, whether they were choosing not to go to school, their parents didn't know they weren't going to school, it wasn't reinforced a lot. So there's a lot of that we see, that they might be 17 years old, but they have a fifth grade reading level. A lack of a lot of trauma going on. So I think there needs to be more trauma services, which obviously a lot of our programs do provide. But if they're coming in for the first time and they have all this trauma, we need something, I guess, earlier on or more available in the community prior to them coming into the juvenile system.
That was quite a bit. I want to take a moment and give that back to you. I heard you said mentorship.
Yes.
Buy-in from the parents.
Educational supports.
Expose them to individuals who have had a lived experience that these juveniles can learn from. Again, some of them are only reading at a fifth grade level, 17 years of age. and they've experienced a lot of trauma.
Yes.
A lot of trauma. So I took notes on that. I'm going to share with this, and many have heard me say this over and over, but I'm starting to see the connection here with what can be a part of the solution. And 8 years ago, this council body moved money to create Closing the Achievement Gap Initiative, CTAG or CTAG. And this initiative does literally everything you said you need. It takes a mentor and literally puts it into the school system, the educational component, where every child should be. If they're not there, they're truant, and we can make sure that they are in school. Okay, so every child should be in one of these 33 school systems that serve the 59 cities that make up Cuyahoga County. So with a mentor in many of these schools, a mentor whose job is to engage the at-risk youth. And I've described them as those who are missed attendance or they've low grades. Again, the trauma you mentioned at home, emotional, social dynamics in their lives that are preventing them from learning 2 + 2 = 4. Or they touch the juvenile justice system, which relates directly to what we're doing. I'm going to add that to my list in my talking points. These at-risk youth, they touch the juvenile justice system. So this mentor engages those youth, pulls them out of their regular class activities at times, engages them, takes them on field trips.
Yes.
Takes them to, they start at 9th grade. And I've learned from my own experience as a funeral director, I have buried too many children who were victims of gun violence, who got involved in destructive activities. Their lives were lost. And then I gather information about them, how, for a death certificate, their birthday, what grade did they finish in school. And to a child, it's almost as if they've never finished high school, 9th, 10th, maybe 11th grade. So again, an at-risk youth. Okay, so with that mentor engaged in their life, starting at 9th grade, which the professionals say is that dropout year. They make 8th grade might be old enough they're thinking about checking out maybe, but they're dropping out around the 9th. If they engage them starting with 9th, now all of a sudden you have a mentor in their life who is taking them to the movies or to bowling parties.
Playing basketball.
Basketball. You need all the resources that you can wrap around that child, but you're gaining that child's trust. So now you're supporting the parental role. When you say, where's the buy-in from the parents? You're supporting the parental role with this. And now what happens is the child starts to blossom. They open up, they trust. If they don't have food at home, then now the mentor links them to the food bank or brings food or whatever is necessary to meet the need that the child has just shared. And all of these things help the child to stay in school, stay successful, and stay on the path of constructive opportunity as opposed to the destructive activities they may have been engaging in. So with that, we did this 8 years ago. And starting with 9th grade, my expectation was we'd have a graduation class in 4 years. We had one in 3 years, the third year. And the reason was because, again, we had targeted at-risk youth. We didn't expect it. It was a pleasant surprise, but some of them had failed in earlier grade, somewhere between 3rd and 8th grade. So now all of a sudden, the light tutoring as well was part of what was done. But now all of a sudden, the children had received their proper school credit, and they graduated on time. It was huge. It was huge. So since then we've expanded into 4 cities so far: Garfield Heights, Maple Heights, Warrensville Heights, and Cleveland Heights. Okay, we have just recently added Bedford Heights. East Cleveland has been added. But the goal there are 33 school systems. So in my mind, if there is a gap, an educational gap, then we need to start to fill it, and we need to bleed into the juvenile justice system as well, wherever they are. Okay, the police do it now in Garfield. If they catch someone who's doing something, now they can bring them in. So that's the way it works. It was very successful. I met with all the superintendents in the last few weeks during our budget cycle, and I'll use Warrensville Heights as an example. They told me 8 years ago they had a 67% graduation rate, and now this year they have a 96% graduation rate.
Awesome.
That's awesome. So to me, there's nothing else to figure out. We simply close the gap. From the superintendent to the janitor, they take the child from the starting line to as far as they get with. Most kids they do well with, but the ones they don't, those are the ones we pick up the slack. So it's not all about closing the achievement gap. It's about everyone, from the janitor to the superintendent, and everyone is a part of the solution. And because the school's not perfect, and I say the same for the parents. The parents aren't perfect. They gave birth to the child, and they're still here with us in the school, or we're in the Justice Center. If we can close the gap, it's everyone's success. So you're not condemning the parent, but you are commending them for the part that they have done and how we help them get them across the finish line when you have success. In the school system, they meet with the parents in the auditorium and give them awards just like the kids. So these are the best practices that are helping engage and help them, the children be successful and then help unify the family too, because it's a broken family just as the broken school system. So this helps all the parts. And I believe this is one thing that we can do to help be a part of the overall solution. And I've said this to GCC as well. We want to be able to all work together to make this a reality, a successful system for our
I'm all about
residents.
collaboration, so welcome it with open arms.
Great. All right. Thank you.
Anything else from anyone?
Since we're closing this up, I wanted to tie into a couple of the comments that my colleague, the council president, made. We have a process, we have laws, and I want special thanks to recognizing the judges and their staff who deal with youth who have fallen through the system. They don't know how to make the system work for themselves. They don't always articulate things well for themselves. Their lack of knowledge of the best way to behave sometimes does not exist. Our communities, though, are dependent on groups like GCC to be activists and social change agents. It's important for them to look at issues. They don't always know exactly who to go to. So just as my colleague said, they came to us. We have one of the few open mic systems as part of government. Judges don't have open mic night once a week.
Yeah.
But county council does. Every time we have a county council meeting, whatever it is, there's public comment. And so that's how that came to us. It is, I think the groups want to be respectful of the system, but they found a way to open the door for a dialogue they think is incredibly important. And it is incredibly important to all of us because society's future is dependent on our next generations. And if too many of the next generation end up incarcerated, we have real problems in where society is going to go and how we will handle the problems of the future. So I really would like to remind everyone to please be patient with everyone at the table. The approach was not perfect, but it is how citizens get the attention of elected officials sometimes. We all know that we sometimes have to make trips to Columbus we don't want to make, where the legislative body does have the power to rewrite laws on our behalf. But occasionally, our residents have decided that Columbus doesn't do it right, and so that's when we get to vote on laws that haven't gotten enough signatures for people to change the process. And sometimes there's pushback from the legislature again, and then we go back again and rewrite the laws statewide because of activists like GCC and many other groups. So I want to thank everyone today who, at my colleagues' urging, came forward and explained to us the process and gave us an opportunity to figure out what we can do here at home before we send our activists to Columbus. Thank you, Mr. Chair.
Thank you.
We have another presentation, so our time is not with us. Quickly.
I think hers will be much shorter than mine, so.
Mr. President. So I'll be brief, and I just want to endorse Council Vice President Stevens' comments and say that I totally respect and appreciate all the work done by the prosecutors and the public defender and the judges and everyone that's involved in the system. But that it is also important to have eyes that are outside of the system, that have perspectives that might not be seen by those who are within the system. And so, Mr. Chairman, I would just urge that if in fact you're putting some kind of a committee together that like it sounds like you're doing, that I just urge that you cast a very wide net and have people at the table that know the ins and outs of this system from the outside, from the inside, and also people who are outside of the system and might bring some different perspectives to the table. Thank you.
Judge?
Thank you.
Thank you. My name is Sarah Sidgic. I'm the Deputy Court Administrator and Chief Legal Counsel for the Juvenile Court. I have a very brief presentation for you. So in light of the kind of interest in public defender versus assigned counsel and how they are utilized in juvenile cases, we analyzed the data. We get that sorted out. So back in January, the court agreed to mirror the general division's assignment process for when cases would receive the public defender, that all new delinquency cases ending in 1, 3, 5, and 7 would be referred to the public defender's office for assignment unless the public defender's office had a conflict or if the youth had a prior case currently pending at the time of the new filing where they were already being represented by an attorney not in the public defender's office, what we would call a prior pending case. So as part of this analysis, we pulled all delinquency filings from January 20th, 2023 through the end of the third quarter, September 30th. I evaluated whether the cases had a conflict in 2 ways. Obviously, I'm not able to, from just the case management system alone, determine all possible conflicts. But the 2 most common scenarios can easily be discerned from case filings. Either one where the case has more co-delinquent, 1 or more, that are charged in the same matter, or where the youth who is the subject of the delinquency case is also a child in an abuse, neglect, or dependency case where their parent or guardian is being represented by the public defender. A youth was considered to have a pending prior case if, at the time of the new filing, the case ending in 1, 3, 5, or 7, they had an other case filed before that time and they were being represented by another attorney. There are, as you'll see in the stats on the next slide, a small percentage of cases where there is no attorney. That can happen for a number of reasons. Either the child has not yet made a first appearance, and so there's not been an opportunity to assign counsel, typically because there's been a warrant issued, or the other likely scenario is it was a very low-level offense for which either the parent waived their right to counsel or it was referred to our diversion center. So this is the statistic that most people refer to when they are talking about how many cases go where. These are all delinquency cases filed in that time period, January through September, and it does show the public defender receiving approximately 34% of those cases. Assigned counsel at 56%. About 7% of those cases were where a child or their family had retained counsel, and then a very small piece, 3%, where no attorney was assigned for one of those reasons I previously mentioned. The bar on the right is just the bind over portion of the cases on the left. So this is the entire universe of delinquency cases for this year through Q3. The problem with this information is that it doesn't encapsulate those conflicts or pending prior cases. So if you look at all of the cases filed this year ending in 1, 3, 5, or 7, and you take out the conflicts and the pending prior matters, you can see that the public defender received 88% of those cases. So this is under perfect adherence to the letter from January, the number of cases that the public defender should have received. So court will admit we were not perfect in our assignments. But if you consider every delinquency case filed for that period of time for the first 3 quarters of the year, so ending in 0 through 9, the public defender received, once you remove conflicts and pending priors, 72%. So they received a total of 729 cases, whereas under the letter, they would have received 448. So this is our evaluation of our assignments and what we believe to be how many cases the public defender has received, that we have given more than what the letter promised, even if it's not exactly under the terms of the 1357 rule.
Any questions?
Just some clarification, Chair. So the percentage of bindovers, assigned counsel versus public defender, am I reading this right? Were there 85% bound over through the public defender's office?
No, this does not.
That's not that.
This is just how many cases were assigned. And
Okay.
the bind over is a subset of the column on
So
the
your
left.
point is simply that more cases are going to the public defender than actually was agreed upon with the, right?
Yes, and more than the statistic typically presented.
Yeah, I mean, what the issue for us was whether, somehow the public defender's vertical system would change the outcome, and I'm not seeing any of that.
Anything further? Yes.
On the first slide, the all delinquency cases,
Yes.
do you know how the 137 bind over cases break down among mandatory and discretionary?
And I don't. It's typically, when you look at our annual reports, about a 60-40 split, a 60% mandatory, 40% discretionary, at least at the time of filing.
Okay, thank you.
Thank you very much.
Thank you.
Well, ladies and gentlemen, yes, Judge, you want to finish it up?
Question of the bindovers. I've been in contact with the prosecutor's office and their statistics in our annual report, and the numbers are different. And the reason they're different is that one group counts people, one group counts cases. And in 2023, as of 11/22/23, there were 62 total juveniles bound over. 23 were aggravated murder or murder. 8 were attempted murder. 24 were aggravated robbery with weapons. 97% of all bindovers had a weapon. There was 1 trafficking case, and there were 4 felonious assaults and 1 receiving stolen property. And the receiving stolen property, 2 cases there had numerous prior adjudications of delinquency. I don't know if that helps answer the question.
And Mr. Chair, it does. So 62 from when to when, did you say?
Up until November 22nd.
Year to date?
Yeah.
Yeah, that's interesting. So 62 basically through the year.
And of those 62, there were, it appears that there were 7, but 2 juveniles bound over on felony 4. 1 was bound over previously, and 1 was bound over on the court's own motion.
Yeah, these are telling statistics. I really appreciate you bringing these to light, and the difference between the people and the cases. That's significant as well.
And we're in the process of rectifying. We have our annual report out. We're gonna change it to be consistent with what the county prosecutor has.
Thank you.
Thank you.
Okay, thank you, Judge, I appreciate it. Okay, I'm glad we had this time to hopefully clear much of that up. As we saw, getting into the legal weeds is not the easiest thing to do and can be confusing to especially those of us that aren't in the legal profession. But I'm glad we kind of had this kerfluffle because it got us to this point. It told us a lot about some of the people in this room, about the concerns that they had and about the jobs that they do and how hard those jobs are. So Judge O'Malley, I apologize that you had to be dragged through this the way in which you did, but out of something bad, usually, not always, but sometimes something good comes, and I hope that we'll be able to deliver something good out of what we've all just gone through. We all have a lane to be in, and the law and the legal portion of this is not our lane. But as the council president stated, we're in a position to help, because in the end we write the checks, and we're very. If you watch this through our process of doing our budget, we're usually pretty doggone careful on how we spend the people's money. At one of our last meetings regarding this, my colleague threw down the gauntlet, Ms. Stevens, and asked if I couldn't put pencil to paper and maybe come up with an idea of where we might be able to go. And I took that seriously, and I thank her for that. Someone might have thought that she kind of threw a hand grenade at me, but I covered it pretty well, and I don't think it as a hand grenade, but an opportunity to blow a hole in the wall. The thing that I think is important to do is to, and not necessarily just get it off our table, but remove it from us right now and put it in the hands of people that know what we're all talking about, have experienced this in real life, have station within our community as respected individuals, and that was the tough part for me. Who is that person going to be that's going to lead what would be an ad hoc committee through this committee, through our leadership, and would report back to us, working with the prosecutor, the public defender, and the juvenile court, as to how we deal with these youth that first touch the legal system. How do we avoid that? And if they do touch the legal system, what's the way forward? The person I came up with was Christine McMonigal. I worked with Judge McMonigal in the court. Her husband, Tim McMonigal, also a judge, are from a rather famous family here in Cuyahoga County. And many in the legal community would agree with me that the McMonigal family is revered, not just for their history as servants of the public, but what they have done for people throughout their lives. So Judge Christine, after some thought, agreed to take control of this ad hoc committee. Mr. Miller, she will be the fisher of men, not I, not you, not anybody up here, and not anybody in this room. I leave it to her to cast her net out to get the appropriate people to serve on this committee. And their charge is simple: help us, help the court, help us, help our constituents with concerns, and help us, most importantly, help the children of Cuyahoga County that are in unfortunate situations where they do touch the legal system. Many of us have been lucky enough not to have that happen in our lives, so many of us don't know what we're talking about. So I would prefer that somebody that knows what they're talking about, and again has lived this and have served, take control of this, have their meetings, find out what their path that they're going to recommend to us, bring it back to us, at which point it is back on our table, and it is our charge then to find the funding to provide to the court and to the prosecutor and to the public defender what's necessary to move this situation forward. Again, I apologize to the court for having gone through this, but I think at the end, there will be sunshine at the end of the tunnel. And for our friends at the GCC, you might not have gone about it the right way. When I met with you, I said there's a pyramid, and I think you turned it upside down. But sometimes turning the pyramid upside down isn't all that bad. So I look forward to Judge McMonigal moving forward with her committee. We will be posting the meetings. We will be posting the individuals that are chosen and accept to be on this committee. And we will provide any necessary means that they need for them to run their committee in a cooperative way. There will be public meetings. As I said, they will be noticed in the public. There will be public dialogue. And I'm certain, after having talked to Judge McMonigal, she wants to hear from just about everybody in this room as to what their position is, and most importantly, how we get to the end of that long tunnel, hopefully with the sunshine on the other end. So with that, I thank my leadership and who agreed with me to move forward in this manner. I thank my committee, who has been patient beyond any means that I could think. This has not been the easiest of things to do, and I'm hopeful, and I'm very hopeful with the leadership of Judge McMonigal, that we'll be able to provide some sort of move forward solutions to the concerns of those in the room. Yes, ma'am.
Mr. Chair, I just wanted to thank you for, forming this committee, responding to the GCC and the public, but there's two things I want to say. One is this should serve as a cautionary tale. What we just went through is to push through funding without a deep dive into the actual policies that might effectuate and attain the goal that we're seeking, instead of just pushing money around in a budget without taking time, sitting down with all the stakeholders. This would have been a complete waste of dollars being moved over to the public defender. And I want everybody in this room to understand that that was the problem. And I, want to hope that colleagues on this body and the administration understand that simply just throwing money around without getting an informed understanding of what is actually happening on the ground cannot happen again. I mean, this just created a mess, and it also wasn't going to solve the problem. The problem that we're looking at, it really is less than we were presented with, and I'm very proud of the work that we're looking at 62 bindovers that, I mean, maybe that's too much, but what I'm hearing, these are pretty egregious offenses. But this body, this council, has always looked at the front end solutions to these outcomes. I chair education. Invest in Children has been a passion of mine to get the children at tiny 1 through 5, get them at that stage. Make sure the parents can read, make sure the children are reading, make sure that if there's trauma, that's addressed. And unfortunately, in this budget, we heard that part of the programs were not funded. I'm hoping mid-year we can do that. But we've always done this as a council. We've always looked at the front loading of dollars to make sure that these outcomes are different. And I think these numbers might bear that out. So I'm proud of my colleagues on that end, that we've always understood that, that it's the dollars up front, getting these kids when they're little. What happened to the magistrates, volunteer magistrates at the juvenile court? I hope those are funded. Maybe we need to look at that to make sure those programs are happening. But those are my only comments. Cautionary tale, we better look at what we're doing. And secondly, keep doing what we're doing on this body, because we are investing early on to make sure these outcomes are different. Thank you, Chair.
Thank you. Okay, again, all thanks. We're done. Thanks for coming. We appreciate all of you being here, and I look forward to Judge McMonigal and her reports. Thank you.